Maritime Academy. Law of Marine Insurance, Part 9. Marine Risks. Introduction. In marine insurance, the insured risks on hulls and cargo may be divided into two broad categories, namely marine risks and war and strikes risks. The term marine risks is a handy expression commonly used to refer to any risks other than war and strikes risks. Marine risks may be further subdivided into the traditional risks such as perils of the seas, fire, theft, jettison, and piracy, together with other recent additions which are not strictly speaking marine risks, i.e. contact with land conveyance dock or harbor equipment or installation, earthquake, volcanic eruption, or lightning and accidents in loading, discharging, or shifting cargo or fuel. They are now insured under Clause 6.1 of the ITCH 95 and Clause 4.1 of the IVCH 95. In relation to cargo, some of these perils are specially insured under the ICC B and C and are generally covered by the ICCA by reason of the policy being for all risks. This chapter examines the risks insured under Clause 6.1 of the ITCH 95 and Clause 4.1 of the IVCH 95, their counterparts in the ICC B and C, and the scope of the all risks cover of the ICCA. Additional or special risks insured under Clause 6.2 of the ITCH 95 and Clause 4.2 of the IVCH 95, commonly referred to as the Inchmary Clause, also sometimes called the Negligence Clause. Thames and Mersey Marine Insurance Company versus Hamilton, Fraser and Company, 1887, which was introduced as a result of the case of the same name, and the three-quarters collision liability of Clause 8 of the ITCH 95 and Clause 6 of the IVCH 95, previously known as the Running Down Clause. Perils of the seas, rivers, lakes, or other navigable waters. The very purpose of marine insurance is obviously to secure the assured with an indemnity for loss of or damage sustained by the subject matter insured during the course of a marine adventure. A marine adventure, as defined in Section 3, occurs when any ship, goods, or other movables are exposed to maritime perils, of which perils of the seas is not surprisingly named as one of the perils. Clause 6.1.1 of the ITCH 95 and Clause 4.1.1 of the IVCH 95 provide coverage for loss of or damage to the subject matter insured caused by perils of the seas, rivers, lakes, or other navigable waters. Definition of perils of the seas. Rule 7 of the Rules for Construction is the statutory definition of perils of the seas. It is restricted only to fortuitous accidents or casualties of the seas. It does not include the ordinary action of the winds and waves. Ordinary action of the winds and waves. The exclusion of ordinary action of the winds and waves from the definition of the perils of the seas in Rule 7 could tempt one to deduce that only weather which is extraordinary or abnormal falls within the scope of the definition. This is clearly a mistaken point of view. The adjective ordinary qualifies the word action, not the winds and waves. Thus, not only extraordinary but also ordinary winds and waves could fall within the ambit of perils of the seas. In the recent case of CCR Fishing Ltd. And others versus Tomlinson Inc. and others, the LaPointe, 1991, the Canadian court pointed out that there are two elements to the term perils of the seas. The cause of the loss must be fortuitous, and it must be of the seas. The word fortuitous clearly excludes any loss which has been intentionally caused by any person, and any loss resulting from inevitable deterioration generated by the ordinary action of the winds and waves. The cause of the loss must not be intentional or inevitable. For the purpose of determining whether an event is or is not fortuitous, the distinction between, on the one hand, what is regular and normal, and on the other, the unusual and unexpected, was used in Popham and Willett versus St. Petersburg Insurance Company, 1904. The issue at hand was whether obstruction by ice was or was not a peril of the seas. It was held that, as the annual regular obstruction of the port by ice in winter was in no sense an accident being part of the ordinary course of things, like the ebb and flow of the tides, the loss was not caused by a peril of the seas. Thus, to fall within the scope of this peril, the ice encountered has to be unusual at that time of the year, creating extraordinary difficulty or danger to navigation. To amplify this point, the ancient case of Magnus versus Buttimer, 1852, needs to be mentioned. The ship in question was in the harbor for unloading when she was damaged as a result of taking the ground on the natural falling and rising of the tide. The court held that as there was nothing unusual, no peril, no accident, the damage fell within the description of ordinary wear and tear. Distinction between sea and land risks. A comparison which has frequently been drawn to facilitate the understanding of the concept is that between sea risks and land risks, it has been said that the requirement of the seas will be met if the loss would not have occurred on land. The test may be simply expressed as whether the accident is one which could only occur at sea. The Inchmari is, of course, the classic case on this subject. Lord Bramwell's description of the position read as follows: "The damage to the donkey engine was not through its being in a ship or at sea. The same thing would have happened had the boilers and engines been on land, if the same mismanagement had taken place. The sea waves and winds had nothing to do with it." Perils of the seas and perils on the seas. The subtle distinction between a peril of the seas and a peril on the seas has invariably been ascribed to the case of the Xantho. But in fact, the distinction was referred to, though not in such bold terms, as early as 1816 in Cullen versus Butler. This case is better known as the authority, which has established the rule that a ship which is sunk due to being fired upon by another ship, mistaking her for an enemy, is not a loss caused by a peril of the seas, but one which falls within the general words of all other perils losses. Frost damage. It would be difficult to argue that damage by frost is a peril of the seas, because it could also occur on land. Thus, with the exception of the ICCA, it would not, unless specifically otherwise stated, be covered under any of the standard Institute clauses. Collision is a peril of the seas. The Xantho, 1887, is also to be credited for laying down the rule that a collision is a peril of the seas. The House declared that a collision, whether caused by a sunken rock, or by an iceberg, or by another vessel, or whether that other vessel is or is not in fault, is a peril of the seas. Thus, no distinction is drawn between a loss caused by the negligence of the crew of the insured vessel and one caused by the negligence of the crew of another vessel. With regard to the former, the assured is protected by the words, even though the loss would not have happened but for the misconduct or negligence of the master or crew in section 55(2)(a. The assured would, of course, be claiming for the loss of or damage sustained by his vessel as a loss by a peril of the seas. With regard to the damage sustained to the other vessel, for which the assured, if held responsible, would be able to claim under the 3/4 collision liability clause, Clause 8 of the ITCH 95, and Clause 6 of the IVCH 95. Unascertainable peril of the seas. There is a species of loss known as an unascertainable or unspecified peril of the seas, described in Lambhead Shipping Co. Ltd. versus Jennings the Merrill, 1992. It is a form of loss which is proved by the drawing of inferences when a ship owner is unable to pinpoint an event or an accident to show that the loss was accidental or fortuitous. Unlike the usual claim for a loss by a peril of the seas, as traditionally understood, the courts would allow an inference to be drawn where the loss is unexplained or where the ship is missing that the ship was lost by reason of an unascertainable peril of the seas. Perils of the seas and negligence. A loss proximately caused by a peril of the seas could well be precipitated by the negligence of the master, crew, pilot, charterer, ship owner, repairer, engineer, stevedore, or any person. Provided that the loss is proximately caused by a peril insured against an assured may, by reason of section 55(2)(a), recover for the loss, even though the loss would not have happened but for the misconduct or negligence of the master or crew. Attention has to be drawn to the following. First, that only the conduct of the master or crew, and not that of the assured, is expressly excused under the said section. And secondly, that the first limb of section 55(2)(a) prevents recovery for any loss attributable to the willful misconduct of the assured, but is silent on a loss attributable to the negligence of the assured. Negligence of master and/or crew as a remote cause of loss. Insurers were liable for a loss proximately caused by a peril of the seas, but remotely by the negligence of the master and crew by section 55(2)(a) of the Act, which states that the insurer is not liable for any loss attributable to the willful misconduct of the assured, but unless the policy otherwise provides, he is liable for any loss proximately caused by a peril insured against, even though the loss would not have happened, but for the misconduct or negligence of the master or crew. In the case of Dixon versus Sadler, 1839, the master and mariners threw overboard so much of the ballast that the vessel became unseaworthy and was lost by perils of the seas. She would have encountered and overcome the perils of the seas if it were not for the wrongful, negligent, and improper act of the master and crew. Negligence of master and/or crew as the proximate cause of loss. A master or member of crew could also, by his negligence and without the aid of the sea or the elements directly or proximately, cause the loss of a ship and/or her cargo. If negligence and not perils of the seas is regarded as the proximate cause of loss, then the above discussion on section 55(2)(a) is irrelevant. Such a cause of loss is now specifically insured under clause 6.2.2 and 4.2.2, commonly referred to as the Inchmari Clause, of the ITCH 95 and the IVCH 95, respectively. These provisions are more fully discussed elsewhere. Negligence of assured as a remote cause of loss. Section 55(2)(a) expressly forbids recovery only for any loss attributable to the willful misconduct of the assured. No mention, however, is made of a loss attributable to the negligence of the assured, as both the Act and the Institute Holds clauses are silent on this point. Reference to case law has to be made in order to ascertain the legal position under the common law. Assured acting as master or crew. The legal position may be briefly summarized as follows. Provided that the act of the assured is negligently and not willfully committed, the loss would retain its fortuitous character, which is essential to constitute a peril of the seas. As far as navigational matters are concerned, his act is no different from that of any other master. Assured not acting as master or crew. Such a cause of loss clearly does not fall within the wording of the last limb of Section 55(2)(a), namely, even though the loss would not have happened but for the negligence of the master or crew. And the principle laid down in the Trinder case 1898 has it is contended to be confined to the special circumstances of the case, the fact that the assured was acting as master when the act of neglect was committed was the main reason for the decision. There are, however, other grounds upon which the court could have applied to support its decision. First, the rationale for disregarding negligence operating as a remote cause lies in the law of causation, though this was not pointed out in any of the cases cited above. Remote causes, whether committed by an assured acting in whatever capacity, a member of crew or any persons, have never played a part in the equation of the rule of causa proxima. The only remote cause of loss which would prevent an assured from recovering under a policy is that of the willful misconduct of the assured. The term attributable to in Section 55(2)(a) has made this very clear. Secondly, Section 55(2)(a) expressly excludes recovery only for any loss attributable to the willful misconduct, but not for the negligence of the assured. In conclusion, a loss proximately caused by a peril insured against, but remotely by the negligence, whether or not committed whilst acting in the capacity of master or crew, of an assured, is as a general rule recoverable. He could, however, be precluded from recovery if the insurer is able to rely upon Section 39(5), which states that, in a time policy, there is no implied warranty that the ship shall be seaworthy at any stage of the adventure, but where, with the privity of the assured, the ship is sent to sea in an unseaworthy state, the insurer is not liable for any loss attributable to such unseaworthiness, or Section 78(4) of the Act, stating that it is the duty of the assured and his agents in all cases to take such measures as may be reasonable for the purpose of averting or minimizing a loss. Perils of the seas and willful misconduct. Scuttling is not a peril of the seas. The reasons for the rule that scuttling is not a peril of the seas are twofold. First, the loss or damage is insofar as the wrongdoer is concerned clearly not fortuitous. A deliberate and an intentional act has caused the loss, and the sea was able to play its part only because it was allowed to do so by man. Such a loss is neither accidental nor fortuitous. It is a certainty. Secondly, equity would not allow a wrongdoer to take advantage of his own wrongful act. The position of an innocent cargo owner and of an innocent mortgagee. A loss or damage caused by seawater intentionally admitted into a ship, whether by a ship owner, master, or crew, or even a stranger, is not a loss by perils of the seas. The willful nature of the act negates fortuity, which is an essential ingredient of the peril. Regardless of whether the claim is brought by a ship owner, cargo owner, or mortgagee, the nature or character of the act is the same. As there is no element of chance or ill luck, the loss cannot be described as accidental or fortuitous. Nobody can recover for such a loss as a loss by a peril of the seas. To protect himself from being excluded for such a loss, a mortgagee should take up the Institute Mortgagee's Interest Clauses, hulls. Naturally, the position is different in the case of a loss caused by fire, which as a matter of construction does not contain the element of fortuity. As such, a loss caused by fire is recoverable even if it was deliberately started by a stranger, a third party to the contract of insurance. Perils of the seas and barratry. Whenever a ship is lost at sea by reason of the entry of seawater, barratry, and a peril of the seas are often pleaded in the alternative as causes of loss. This is because seawater could accidentally or fortuitously enter a ship and cause a loss, or could be invited to enter a ship to cause a loss. In the case of the former, the action of the winds and waves, that is, perils of the seas, would be regarded as the proximate cause of loss, whilst in the latter, either barratry or willful misconduct on the part of the ship owner would be considered as the proximate cause of loss. In any event, scuttling a ship, whether done with or without the knowledge or consent of the ship owner, is not a peril of the seas. It is suffice to mention here that the distinction between a peril of the seas and barratry is well defined. The former is a fortuitous act, whilst the latter is an intentional act committed by man, the master, or crew. Seawater could be intentionally admitted by the master or crew with or without the knowledge or consent of the ship owner. Such an act is known as scuttling. In the case of the former, the cause of loss is willful misconduct, whilst in the latter, it is barratry. Perils of the seas and wear and tear. Unless the policy otherwise provides loss or damage caused by ordinary wear and tear, is as a general rule excluded by Section 55(2)(c) as a risk not insured against, loss or damage caused by the ordinary actions of the winds and waves, which has been expressly excluded by Rule 7 of the Rules for Construction from the definition of perils of the seas, is a loss caused by ordinary wear and tear. The word ordinary qualifying the actions of the winds and waves appearing in Rule 7 was inserted for the purpose of eliminating losses resulting from ordinary wear and tear. Loss or damage caused by ordinary wear and tear is not covered by reason of the fact that it is an inevitable loss, a certainty, and therefore not a peril. In Wadsworth Lighteridge and Coaling Co. Limited versus Sea Insurance Co. Limited, 1929, the sinking of the ship through general debility was held not to have been occasioned by perils of the seas, although she had been sunk by the entry of seawater. Perils of the seas and unseaworthiness. A seaworthy ship, as defined by case law and Section 39(1), is one which is reasonably fit in all respects to encounter the ordinary perils of the seas of the adventure insured. This necessarily means that if she is incapable of enduring even the most ordinary of sea perils, she cannot be said to be seaworthy, and consequently the loss cannot be attributed to perils of the seas. It would be very difficult indeed to argue that a loss is proximately caused by the sea if the ship is unable to endure the expected, ordinary, and foreseeable perils of the seas of the adventure insured. In such a case, a judge would be more inclined to find that some aspect of her physical condition, for example, latent defect, wear and tear, or unseaworthiness, must have caused the loss. The case of Merchants Trading Company versus the Universal Marine Insurance Co. 1870 may be referred to illustrate this point. The defense of a breach of the implied warranty of seaworthiness was in this action successfully raised by the insurer, as the ship lying quietly at anchor was unable to keep herself afloat in still water. Accordingly, the court had no alternative but to rule that her unfit condition caused the loss. The test used by the trial judge, which was approved by the appeal court, was worded as follows: whether the leak was attributable to injury and violence from without or to weakness within. Voyage policies. Section 39(1) of the Act, relating to the implied warranty of seaworthiness, is applicable to all voyage policies, regardless of the nature of the subject matter insured. If the ship is unseaworthy at the commencement of the voyage, this would constitute a breach of the implied warranty of seaworthiness, for which the insurer is automatically discharged from liability as from the date of breach. On such an occasion, it would not be necessary for a hull's insurer to show the cause of loss, or for that matter, that unseaworthiness caused the loss. His defense would simply rest on the premise that a warranty has been breached, and consequently, he could not be made liable for any loss or damage, however caused. Time policies. The consideration's really one of fact. The court has to find, as it would have to in any other cause of action, the proximate cause of loss, be it perils of the seas, unseaworthiness, or any other cause. Even though Miss J.J. was found to be plainly unseaworthy by reason of defects in design and construction, her physical condition did not cause the loss. The assured had no idea that she was unseaworthy because the defects in design were latent. In Frangos and Others versus Sun, Insurance Office Limited, 1934, the fact that the vessel was unseaworthy was held to be inconsequential because Perils of the Seas was held to have proximately caused the loss. Fire and explosion. Fire and explosion are specifically insured under Clause 6.1.2 of the ITCH 95, Clause 4.1.2 of the IVCH 95, and the ICC B and C. As explosion is now specially named as an insured peril, the question which had so troubled the courts in the past as to whether it was included within the term fire is now academic. These perils are also covered under the ICCA by virtue of the policy being for all risks. Fire negligently started by the master or crew. The cases have demonstrated that if a fire has proximately caused a loss, any negligence committed by the master or crew is irrelevant. This rule is now encapsulated in Section 55(2)(a). A ship owner could also rely on Clause 6.2.2 of the ITCH 95 and Clause 4.2.2 of the IVCH 95 to claim for such a loss. However, if he wishes to plead that the loss was proximately caused by the negligence of master officers, crew, or pilots, he would have to satisfy the terms of the proviso to the said clause. Fire willfully started by the master or crew. The position of a ship owner and an innocent mortgagee. Under the ITCH 95 and the IVCH 95, loss of or damage caused by a fire which has been deliberately started by the master or crew without the connivance of the ship owner is recoverable under both counts of fire and barratry. Obviously, if the fire was started with the connivance of the ship owner, it would not constitute barratry because barratry is by definition an act committed to the prejudice of the ship owner. Neither would the ship owner be able to recover for a loss by fire for being himself guilty of willful misconduct. He would be barred from so doing by Section 55, 2A of the Act. Like a ship owner, a mortgagee, provided that he himself did not set the ship alight, or was a party to the ship being set alight, would also be able to recover for a loss or damage caused by a barratrous fire. He has a right of claim, whether he sues as an assignee of the ship owner's policy or as an original assured under his own hull's policy or the institute mortgagee's interest clauses. The position of an innocent cargo owner. A cargo owner, however, is in a different position. Even though fire is specifically named as a peril insured against under the ICCB and C, nonetheless, he would not be able to recover by reason of Clause 4.7. It is to be noted that, though Section 55 2A excuses not only negligence, but also the misconduct of the master or crew, the provision is prefaced with the words, unless the policy otherwise provides. The ICC, B, and C have through Clause 4.7 otherwise provided that loss or damage caused by deliberate damage to or deliberate destruction of the subject matter, insured, or any part thereof by the wrongful act of any person or persons is not covered. The position under the ICCA is, however, different. First, as this is an all risks policy, and there is nothing in Clause 4 to exclude a barratrous fire, the loss is recoverable. Secondly, support could be drawn from the fact that there is no equivalent to Clause 4.7 of the ICCB and C in the ICCA. Thirdly, a case could be made of the fact that the Institute Malicious Damage Clause is available to be used only with a policy, such as the ICCB and C, which contains an exclusion for deliberate damage and deliberate destruction of the subject matter insured. Fire negligently started by the assured. It is difficult to envisage how an assured, such as a cargo owner or a mortgagee, could negligently start a fire on board a ship. A ship owner, however, could negligently cause a fire if he was to act as master of the ship at the time of loss. Section 55 2A denies an assured the right of recovery only if he was guilty of misconduct, but not negligence. The law in relation to the peril of fire is in this regard the same as that relating to negligent navigation. The loss would still be considered as having been proximately caused by perils of the seas, even though the assured who, acting as master, was negligent in navigating the ship. Fire willfully started by the assured. It is pertinent to note that Section 55 2A excuses only the misconduct of the master or crew, but not that of the assured. Any loss brought about by the willful misconduct of the assured, whether he be the ship owner, a cargo owner, or a mortgagee, is clearly excluded by Section 55 2A. Fire willfully started by a stranger. In the Election Hope, 1988, Lord Justice Lloyd remarked that a fire would still be the proximate cause of loss, even if it was deliberately started by a stranger to the insurance. Any person who is not a party to the contract of insurance is a stranger. The same principle, but worded in terms of the mischievous person, was proposed by Mr. Justice Salmon in Slattery v. Mance, 1962, who pointed out that the risk of fire insured against is quite obviously not confined to an accidental fire. If the ship had been set alight by some mischievous person, e.g. a vandal, a stowaway, or a stevedore who is not a crew member, without the plaintiff's connivance, there could be no doubt that the plaintiff would be entitled to recover. The position of an innocent mortgagee. Whether a ship owner could be classed as a stranger vis-a-vis a mortgagee was considered in the Alexian Hope, where the plaintiffs were mortgagees suing under a mortgagee's interest policy issued by the defendant underwriters. The question raised was whether they could recover under the policy for a loss caused by a fire deliberately started by the ship owner. The Court of Appeal and Mr. Justice Stoughton in the Court of First Instance held that so long as the plaintiff's assured mortgagee were not themselves guilty of any willful misconduct, they were entitled to succeed under the policy. For all intents and purposes, the act of a ship owner is in relation to a mortgagee the act of a stranger. But as discussed earlier, if the ship owner himself were to claim for the loss of his ship under his own policy of insurance, he would fail in his action. It is necessary to recapitulate that the position would be different if a peril of the seas were to cause the loss. To elicit this distinction, it would be helpful to recall the remarks made by Mr. Justice Evans in the Captain Panagos D.P. 1986 that fire, unlike perils of the sea, does not itself connote a fortuity, as fortuity is not an essential ingredient for the peril of fire. It means that all forms of fire are covered regardless of whether they were started accidentally or deliberately. In terms of proof, the assured does not have to prove, as in the case of perils of the seas, that the loss is fortuitous. All that he has to show is that the loss is proximately caused by fire or by precautionary actions taken to prevent the ignition of or the spread of a fire. The position of an innocent cargo owner. A cargo owner who takes out a policy of insurance under the ICCB or C is, unfortunately, not placed in the same position as an innocent mortgagee described above. Even though the fire may have been started by a stranger to the contract of insurance subscribed by the cargo owner, he is, for the same reason as in the case of fire willfully started by master or crew, barred from recovery by Clause 4.7. To insure himself against such a cause of loss, he would have to take up the Institute Malicious Damage Clause. As regards the ICCA, the reasoning given to the case of a fire willfully started by the master or crew discussed earlier also applies here. Violent theft by persons outside the vessel. Definition of theft. Clause 6.1.3 of the ITCH 95 and Clause 4.1.3 of the IVCH 95 insure against theft in terms of violent theft by persons from outside the vessel. Theft is not an insured risk under the ICCB and C. To provide coverage for this peril, the assured must seek either an all-risk policy in the form of the ICCA or the Institute Theft, Pilferage, and Non-Delivery Clause. Rule 9 of the Rules for Construction of Policy states, the term thieves does not cover clandestine theft or a theft committed by any one of the ship's company, whether crew or passengers. The provision in the ITCH 95 and the IVCH 95 is in fact a restatement of this definition. There are essentially two components to the peril. First, it has to be violent, and secondly, it has to be committed by persons from outside the vessel. Violent theft. The exclusion of clandestine theft from the statutory definition is now made clearer by the use of the word violent in the Hulls clauses. La Fabrique de Produits Chimiques versus Large in 1923 is the authority for this requirement. Mr. Justice Belhage had no doubt that in a policy of marine insurance, pure and simple, the risk of loss by thieves does not cover an ordinary clandestine theft, but only theft accompanied with violence. In this case, the thieves had smashed 2 sets of doors in order to gain entry into a warehouse. The case is also an illustration of the fact that to constitute theft, there does not have to be an assault upon some person. Violence to property will suffice. To exclude furtive theft, American policies employ the term assailing thieves to describe the risk. Athens Maritime Enterprises Corporation versus Hellenic Mutual War Risks Association, Bermuda, Limited, the Andreas Lemos, 1982, illustrates the point that the time at which violence is used or displayed is crucial. On this occasion, the gang armed only with knives used force to make good their escape. As the act of appropriation had already been completed when force or a threat of force was used, the theft was held to be clandestine in nature. As violence was not displayed before or during the commission of the crime, the acts of the gang did not constitute a riot, theft, or piracy. Any force or violence demonstrated after the crime had been accomplished does not constitute theft or, for that matter, a riot or piracy. Persons from outside the vessel. Even as early as 1874, the term theft had already acquired a certain fixed meaning in the law of marine insurance. In Taylor versus Liverpool and Great Western Steam Company, 1874, a dispute in relation to an exception of theft under a bill of lading, all the judges pointed out that even though the word theft was ambiguous as to policies of insurance, it had always been associated with theft by persons outside the ship and not belonging to it. The concept of theft in marine insurance refers to acts of depredators outside the ship, the thief who breaks through and steals. Dishonest intention. All the judges agreed that dishonesty is an essential ingredient for the offense of theft, and unless dishonesty is shown, no one should be branded as having committed a theft. Jettison. Very little need be said about jettison save that clause, 6.1.4 of the ITCH 95, and clause 4.1.4 of the IVCH 95 refer to the jettison of part of a vessel's equipment or furniture. The general principles discussed earlier in relation to cargo are also relevant here. As in the case of goods, a ship's equipment or furniture may have to be jettisoned at a time of danger. Such a loss incurred by the ship owner is recoverable as a general average sacrifice. Piracy. Piracy has over the years been shuttled back and forth, first as an insured peril under marine risks, then under war risks, and has now reverted back to marine risks policies of insurance. It is now specifically insured under Clause 6.1.5 of the ITCH 95 Clause, 4.1.5 of the IVCH 95, and under the ICCA, by reason of the policy being for all risks, but is not insured under the ICCB and C. It is to be noted that piracy and barratry is specifically accepted from the war exclusion clause, clause 24.2, of the ITCH 95, and clause 21.2 of the IVCH 95, and clause 6.2 of the ICCA, but not from the war exclusion clause, clause 6.2 of the ICCB and C, because it is unnecessary to do so. Definition of piracy. Rule 8 of the Rules for Construction states that the term pirates includes passengers who mutiny and rioters who attack the ship from the shore. The definition, as suggested by the word includes, is by no means exhaustive, and case law has to be referred to for a fuller understanding of the concept. Nesbitt versus Lushington, 1792, is perhaps the earliest of cases to touch upon the subject of piracy. In a violent and unlawful manner, an armed mob attacked, boarded and arrested the ship, and forced the master to sell to them a cargo of corn at a reduced price. The court had no doubt that such an act was piratical in nature. In Palmer versus Naylor, 1854, a group of emigrants murdered the captain and part of the crew and carried away the ship. The court held that the seizure of the vessel, the taking her out of the possession, and control of the master and crew and diverting her from the voyage insured were direct acts of piracy. The locus classicus on the subject is Republic of Bolivia versus Indemnity Mutual Marine Assurance, Co. Ltd., 1909, where the Court of Appeal, which had to interpret the meaning of the word piracy and insured peril under the policy in question, held that it meant piracy in a popular or business sense. A pirate is a man who plunders indiscriminately for his own ends, and not a man who is simply operating against the property of a particular state for a public end. Such a man would satisfy his personal greed or his personal vengeance by robbery or murder. As the goods intended for the Bolivian government were seized by Brazilian malcontents who were acting purely for public and political motives, the loss was held not to have been caused by pirates. Later, in the Andreas Lemos, 1982, it was declared that force or the threat of force is an essential element of piracy, and this has to occur at such a time as to cause the loss. Another issue which concerned the court was whether piracy had to occur within territorial waters. On the first issue, Mr. Justice Stoughton held that theft without force or a threat of force is not piracy under a policy of marine insurance. Furthermore, because the act of appropriation had been completed when the force or a threat of force was used, the loss was not a loss by piracy. He pointed out that the very notion of piracy is inconsistent with clandestine theft. In the light of the fact that both the perils of theft and piracy require the use of force, it may be difficult to distinguish between them. In fact, he acknowledged that most, if not all, pirates are also thieves, but the exclusion of the piracy from the marine cover by the FCNS clause refers to pirates, who are thieves as well as any other pirates. On the second question as regards the place for the commission of the act, it was decided that there was no reason to limit piracy to acts outside territorial waters. In the context of marine insurance, if a ship is in the ordinary meaning of the phrase at sea, or if the attack upon her could be described as a maritime offense, then for the business purposes of a policy of insurance, she is in a place where piracy can be committed. Contact with land conveyance, dock or harbor equipment, or installation. If it were not for this clause, any loss or damage sustained by a vessel which collides into fixtures or landed objects such as a land conveyance, dock or harbor equipment, or installation would not be recoverable. For strictly speaking, such risks are not maritime in character and therefore do not fall within the cover for perils of the seas, nor the 3/4 collision liability clause. If a vessel were to incur damage by toppling over in a graving dock repair yard, or by colliding into a dock wall, such a loss would be recoverable. Earthquake, volcanic eruption, or lightning. Clause 6.1.7 of the ITCH 95 and Clause 4.1.7 of the IVCH 95 are self-explanatory, covering damage caused by earthquake, volcanic eruption, or lightning. The cost of the removal of volcanic dust immediately comes to mind as a loss falling within this cover. Accidents in loading, discharging, or shifting cargo or fuel. The above clause, now contained in Clause 6.1.8 of the ITCH 95 and Clause 4.1.8 of the IVCH 95, was originally inserted as a result of the decision of Stott Baltic, Steamers Ltd. versus Martin and others, 1816, where the House of Lords decided that damage caused to the hull when a part of the crane's tackle broke, causing the boiler, which was being lowered, to fall into the hold of the ship, was not recoverable as a loss by peril of the seas, as neither sea perils nor any of the then enumerated additional perils of the Inchmarie Clause had caused the loss. It was held not indemnifiable. Having been moved from Clause 6.2 of the ITCH 83 to Clause 6.1 of the ITCH 95 means that it is now no longer subject to the due diligence proviso. End of Part 9. Maritime Academy